I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of the circumstances in Jamaica? Or was it intended to be influenced by comparative human rights jurisprudence, looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa. Mm-hmm. And if you even the Canadian and the United States, but what you see, what a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21. Yeah. But what's significant is that what is clear is that there is similar to in the Canadian jurisdiction that the test, which is the demonstrably justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. Yeah. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislation.
Oh, yes. Yes, and I see paragraph 13. Yes, sorry.
My lords, when we broke, I was making submissions about Putnam. Just one thing, I need to move on, but one thing that I would just emphasise about Putnam is the language that Lord Justice Bingham, as he then was, used towards the end of page 759 in that passage where he talks about collective integrity. And he talks about the high regard in which juries are held depending on their collective integrity and their individual integrity. And that's important in one sense, because it demonstrates how, in our submission, judges actually, although obviously judges need to avoid discharging unnecessarily because it's a waste of resources, etc., at the same time, judges should not be reluctant if the circumstances arise to discharge the jury, because it's by doing that that the regard of the jury is, in one sense, preserved. It has one other factor, that it has one other result, which in our submission is demonstrated by the facts of this case, and explains why discharging the jury is not that uncommon, we would submit, and that's that discharging the jury in the right circumstances prevents people having to then exercise appeal rights, essentially potentially being held on appeal, in custody rather, until the appeal is heard. It ensures effectively that someone's fair trial rights are vindicated as soon as possible. I'm going to move on fairly quickly because of time, but there are a couple of things I just want to make, a couple of points I want to make about the suggestion, which seems to be at the heart of the prosecution case, essentially, which is that all of this could be dealt with by jury directions. And the first point I want to make is it links back to the question, or the point I think my Lord Reid put to me just before lunch. Jury directions obviously can be, I was about to say but I don't think it won't always be the case, and that's why I changed my language. Jury directions can be important ways of keeping a trial on track. The fundamental problem, though, in this case, there are two fundamental problems that explain why jury directions, even if they had been in stronger terms than the ones in this case, would not have been enough. And the two fundamental problems are this. Firstly, it goes back to a point I made this morning. One of the jurors had already been willing to offer bribes. He was willing to break the law. Directions assume that the juror will comply with what they're being told. But if a juror is willing to demonstrate that they are willing to break their oath, willing to act unlawfully, directions cannot solve that in our submission. The second problem with a direction is that implicit in Putnam, and what is said in Putnam about the potential for late reporting, for example, demonstrating that a juror had failed to comply with their oath and was going to be unable to avoid being biased. Implicit in Putnam is the need to know how far the poison has spread, to use the language of Putnam, before giving a direction, because directions will only work if the poison hasn't spread too far or hasn't become too deeply embedded in individuals' thought-making process. Here, because of the limited information about what had actually occurred, in our submission, there was no way of knowing whether the directions were sufficient. And that's one of the reasons why questioning the jury can be important. We would say, and I'll come back to this in reply if necessary, but it's probably clear from our case. In any event, all that was said in this case, of course, was that the jury were reminded of their oath. Smith, I won't take you to it, but it's 7671, House of Lords at para 24, makes it clear that directions need to be apposite, clear, and emphatic. They were not in this case. And there's no reason why the jury couldn't have been expressly addressed effectively about bribes and how they should ignore the bribery attempt. Because, of course, on the evidence given, or the account given by the forewoman, not technically evidence, but on the account given by the forewoman, everyone was aware that there'd been this approach. Everyone was aware that one of their number had been placing a bribe. But as I say, fundamentally in our submission, this was a case, and there have to be those cases where it's just gone too far. The Crown has raised the issue of the proviso. In our submission, the proviso is inappropriate in this context, and we've certainly, neither side has been able to identify, as far as I'm aware, any case where the proviso has been applied in circumstances where an appellate court has reached the conclusion that bribery or similar problems have occurred. The reason for that in our submission is this. Under the Charter, as you've seen, there is a constitutional right to be tried by an independent tribunal. The Jury Act, unsurprisingly, given what is common practice in many countries around, provides that that trial must be by a jury. No one, as in this case, none of the defendants in this case, have waived their right to trial by jury. Waiver, we make reference to it. Again, I won't take you to it because it's probably trite. Miller and Dixon, Lord Bingham, waiver has to be voluntary, informed, and unequivocal. The reference to that, if you want it, is page 7008, paragraph 31. So no one has waived their rights. If the proviso were to be applied by this court in relation to the jury issues, it would be this court then effectively deciding on guilt, having not heard any evidence, having not been able to assess the witnesses, having inevitably, and this is no criticism of any party, having inevitably limited information. And that's, as I say, not consistent with the rights that I've just described, the clear rights as a matter of Jamaican law to trial by an independent jury. That's why in our submission, the Court of Appeal was right in Brown to say it doesn't matter what, effectively paraphrasing, what the strength of the evidence was, because ultimately there was a right to trial by an impartial tribunal. We submitted yesterday a judgment in the supplementary authorities bundle by Chandon, which is a judgment of the Court of Appeal of Guyana. Page 16 and 17 of that supplementary bundle, which is page 226 and 227 of the report, which is last two lines of page 16 and the first 5 of the next page, adopts the approach I've just described, which is saying you can't apply the proviso because there was a constitutional right to trial by 11 jurors. Actually, not a constitutional right, but a right as a matter of law to trial by 11 jurors. One of the reasons for that, I've given a number of sort of fairly fundamental reasons. That's obviously also consistent with the approach in Putnam, as I took you to. One specific reason for that is that, as this court will be aware, and as is clear, for example, in the judgment in Bonnet-Taylor, which is in the authorities at 6289, paragraph 20, the normal approach that is often adopted in things like fresh evidence cases is to consider the impact, essentially, of whatever occurred or didn't occur on the juries, on the jury. Well, in a fresh evidence case, one can do it, and what that does is respect the role the jury plays. It looks at what the jury must have concluded, which is that the individual who's appealing was guilty, and then considers what impact fresh material might have. Here, one doesn't have that starting block, and that's why applying the proviso essentially would be this court determining for itself guilt, because it doesn't have a reliable starting point. So in my submission, it's not surprising that simply that it doesn't appear to be any case where the proviso has been applied in a case where there's a problem with the jury. Well, a problem in the sense of certainly a lack of independence. I mean, there may be other problems, but my Lord,
I'm sorry, I'm not meaning to look pained.
Yes.
I'm trying to remember an authority. We had a case in this court, we had a case in the Supreme Court a few years ago where the judgment was given by Lord Wilson to do with unfairness by a trial judge.
yes.
And the court, in the judgment, Lord Wilson said words to the effect that a judgment which is a result of an unfair procedure is a thing writ in water from which nothing can follow. And you might rely on that idea in relation to a verdict by a jury which one could not be confident was an unprejudiced jury.
Well, my Lord, yes, but in one sense, I would put it even higher because of the role the jury plays in our system, because of the importance of the integrity of the jury being preserved, and because there is, in particular, a constitutional right to an impartial and independent tribunal. I mean, they are really important rights within the system of criminal justice. To state the obvious, to state the and you are potentially denying that. I'm helpfully, it's extraordinary how quick juniors are these days. Seraphin, I'm told, is the judgment,
right.
para 49.
Yes.
Turning then to the issue of time of jury, I'm not going to spend very much time on it, partly because obviously the jury shouldn't have been retiring at all on our case. But it does, in one sense, add to the overall concerns about this case, because it's quite clear, and the Court of Appeal recognised this essentially, that one of the reasons why the judge was keen to get the jury out, so as to speak, is because the trial couldn't continue without that juror. And so you had this situation where there was a potential need to take action against a juror who, and so a quick verdict was being sought. Now, the Jamaican bench book clearly recognises the potential pressures that can be put on a jury, and we would submit that one of the problems, if you have a jury that already has poison within it, to use that language again, one of the problems with pressure, the problems of pressurising the jury be potentially is going to potentially be influenced by unconscious bias. That risk increases if people are effectively pressurised to take a quick decision, not think through the evidence. You go to your prejudices, unfortunately. If you some people tend to go to their prejudices if they're under pressure. That's the simple point I'm making, and that there is clearly a recognition now that sending a jury out late puts pressure on them, and it particularly puts pressure on them in a situation such.
I don't know. Sometimes counsel, the microphone set back here, they'll read out the judgment to the public or whoever counsel is available. So if I'm going to say, if you're sitting where this gentleman is here, remember the public, you'll be sitting there and you listen to the verdict of what they're going to give for this vote.
Mm-hmm. It's not they're putting out and then everyone's got to vote.
No. They pre-decided.
Some people come for vote. The guys are finding them come for vote. They say, can we vote?
It's see downstairs. Like you've got three. You've been three. It's funny though, when we come back here again, three's one of the nicest rooms. What I mean is that when they've got all the little flags of the British territory, I don't put them around them. Oh, that's okay. Oh, yeah. No, that's down. Yeah, that's good. Oh, yeah, because you've got the same logo that you'll see here. It's everywhere here. And if you notice on their badges as well.
Yeah, that's it.
It's like a big version of the British Isles.
That's what I was saying.
And you see courtroom 2 as well. That's I call that the glass court.
Yep.
Because when you go inside there, go up to the bench itself and turn around and look at the glass wall. You see like an inscription etched.
Tell me the cost. Somebody, this is random. Somebody said, tell me the cost of the concert ticket. Because we know the artists are coming. All right, so you see the skybox is 12 million. The champagne stands area or the cabana is 3 million. The bleachers, about 30 grand. The VIP is 50, but now just don't tell about it.
This is not the original room, this has been redone up. I think they've got.
Salute me for the.
You can ask by reception.
Wait for the side gate ticket them.
The original room will how it used to look, but ask by reception.
Oh, greetings. All right, give me a second, bud. All right. Yeah.
No, but those one flight down and look at the glass.
Yo, like up the video, no man, and share around. I don't know a world boss judgment day today, no man. Just like up the video and share. Mr. Isaac Buchanan in a court right now. Like up the video, share.
Yeah, I did. Oh, you back again today? You know, I asked him if it was him, and he said no, it was as he was here today. So you're here for them again today. No, I can't do the pre. I'm on a what they call it, gag order. Can't do pre. No, no one can do it. Not even that. I'm not engaged in the music, but definitely. All right. So how far are you gonna do? Because it's oh yeah, no man. I'll wait for you downstairs. Okay. I can't get my number. All right, hold on. Let me. It's via WhatsApp, right? Yes. All right, just look. No, I'm just sure. Just look. I can't say it. Just no, don't say it. Don't say it. No, just take the number. All right. You seen it? You saw it, right? Okay. Next thing we're gonna call up a number then. No. Is the DPP coming? You asked me. Oh, I can't speak for the DPP. Oh yes, my side will be here. Okay. Yes. So that she starts at 4 or business starts at It's 4, exactly 4. It's gonna be about 20 minutes. Yeah, and then everybody walks for like I just saw, but yeah. But then when I leave, it's not gonna be like yeah, and then so they're not gonna be here. All right, no problem. No, this. I'm in the UK. See, UK. I'm in the judgment room right now. Oh yeah, it's 11 o'clock for you. There's only half an hour left. Only half an hour. So I guess I can't be saying it's 4, but I'm in the UK, so I'm actually on the ground in the judgment room, waiting on the 3 justices, the 3 the lords. And the US is a hour ahead. Somebody said, make sure. Once we see the live, make sure you discount the gifts out to the boss. What? Oh, so the gifts is payment. All right. I hear you. I'm never giving you that joke about cost orders when this is done. I can't wait for this done so we can talk. Hello, how you doing? Hold on. People, look, see them. Who is that? Say them. See them and our pretty friend. Can we not see them? Can I see them? How you doing? You good, bro? Oh, yeah, I see. So I'm for send me money, go there for the Bobby show that again. Yeah, I'm a troublemaker. Yo, behave yourself, because you know you have some people out there recording you. See them, I'm making money off you. Every time I send me a money gun, I have to show you. I'm joking. What a team. David, big up yourself. Charming. Charming. Well, just expose them, I can't read. Who got high blood pressure? Calm down. Put it on lockdown. See them, you nervous? Are you nervous? Yeah? You're nervous? Charlie's Angels nervous. No, should I say Charlie's Angels? Gaza Angels nervous. Yeah. They're nervous. Can't do that. All right, so I don't know if I'm religious, but I'm gonna cut my life because I'm gonna go pray. St. Thomas, you know what to do. Just send up to prayer and re-up the gathering, you know? So, all my people's in St. Thomas, y'all know what it is. It's that time, so I'm going to cut the live. Live didn't nice, you know, but y'all join me later tonight. So if you're in Jamaica, 5 p.m., Context Matters for my special guest. Yeah, but for those of you, it's that time, you know, Psalms 121 and Psalms 91. That's all that's required. God on time, you know what I'm saying? Yeah. So once again, so big up.
Which recognises flexibility both ways. And so in complex cases, remember this is apparently one of the longest criminal trials in Jamaica, necessary to complete the summation earlier than 3 p.m. to avoid pressure.
I'm sorry, could you give me that page number?
Sorry, 6801, it's paragraph 5.
8601.
No, 6801.
Oh, I beg your
Sorry,
pardon.
no, that was probably me.
No. Later on.
And of course, in this case, you had the added complication that when the jury was sent out, they came back essentially at 5:35, were asked if they'd reached a unanimous verdict and said they hadn't. The reference to this is 5176. The prosecutor then pointed out that they'd not been out for 2 hours, which is the point at which a majority verdict would be reached. There's no direction essentially saying you may want to, you need to try and reach a unanimous verdict. That's inconsistent with another passage of the bench book that is at 8362.
And can I ask, in Jamaica, if they go out and they haven't returned a verdict by a reasonable time in the evening, is the practice to send the jurors home, or are they sequestered in a hotel?
They cannot be sent home, so they have to be sequestered, basically.
Yes, and so are they kept in a hotel under court supervision?
That would be my understanding, what we like. But obviously, the bench book is premised on the idea that it's ideal that that doesn't happen, really.
Yeah, but even sending, I mean, I know from my own experience, even sending out the jury earlier in the day, that you can still have them out overnight.
Yes, absolutely, obviously, and that's not uncommon.
In fact, sometimes it takes a number of days before they return a verdict.
But does sequestering happen in Jamaica? Because I noticed there's another case where the hearing went on until 1:30 in the morning, where you would have thought they'd all be in a hotel by then.
No, in practice, sorry, I should have been clear. In practice, it doesn't, because there's just no real provision for it. So the jury just stay late.
But there is a rule that they can't be separated once.
The Jury Act is clear on that. They can't be separated.
So deliberations can go on for days and they'll just be kept without being sequestered in a hotel?
In principle, I suspect in reality that doesn't happen because of the natural I mean, we haven't put this in because it didn't seem relevant, but there is old English case law about juries being reaching verdicts at 3 in the morning.
Yeah.
Yes, well, the leading case on coercion of a jury is one where the judge refused to let them have anything to eat or drink until they returned a verdict.
Have you got the reference to the Jury Act indicating that the jury cannot be?
Yes.
Once they've started deliberation, can't be.
Yes, I'll get
sent home.
I have got that in my notes. Sorry.
Well, don't bother now, but if it's not immediately, if somebody could just.
Yeah, no, sorry, I just, it's section 47 of the Jury Act, which is electronic bundle 6805.
Thank you.
I think actually, just sort of an aside, it was George Davis, if you remember the George Davis is innocent. He was an early hours of the morning verdict, if that's a sort of historic.
That's not that long ago.
Yeah.
But they can be sent home, as I understand it, before they start to deliberate.
Yes.
So the judge who finishes summing up, say at tea time, could just say to the jury,
well that's why
come back tomorrow and you'll deliberate.
Well, that's why the bench book makes express reference to when you finish your summation, because that's really what the suspect happens. I mean, my experience of English courts.
Save the last direction about unanimity and electing a foreman until first thing the next morning.
Exactly, and that's not uncommon even in England, where you're getting late.
Regular.
You have 2 minutes worth of summing up.
Yeah.
But paragraph 5 in the bench book rather suggests that the solution is not, if you finish your summing up late, to send them home, but not to finish your summing up late.
Well, I think that it's because of the technical issue of when do their deliberations start. But all you need to do is have like one line of your summing up, and that.
Okay.
Are you sick of having issues with your webinars, wasting tons of time on troubleshooting with attendees? If so, you need StreamYard.
47.3 at page 6805 does imply, well, it does say that the judge can give directions as regards accommodation.
Yes, but I understand in practice, and obviously I don't have direct experience, but those who do tell me this, that in practice that's not applied.
Thank you.
Final issue, and as I said, there are obvious issues in relation to the time in this case, particularly given the complexity of the case. In terms of what you should do if you're with me and have concluded that the conviction should be quashed and the proviso shouldn't be applied, we would invite the court not to remit. This has obviously been outstanding. The appellants have all been in custody since the 30th of September 2011. That delay is likely to have had an impact on evidence. There are, as the court will be aware, because of the application for expedition, there are issues with the health of one of the appellants. There are also obviously constitutional issues, but they've been denied. We would submit constitutional issues, even if it's the jury point. They have a constitutional right to a fair trial. If we're wrong about that, though, we would invite you to consider remitting to the Court of Appeal so that the Court of Appeal can consider the issue of retrial. That, I think, concludes all I have to say. I think Mr. Buchanan has some additional submissions.
Yes.
Yes, Mr. Buchanan.
If it pleases the court, Lord and ladies, I just wish to make a point, a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones, and this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings, the concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned. So she only heard the information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true. And then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman and more conversations about her role. And so the taint or the poison would have gone back as far as November in a 65-day trial and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked what their responses would have been for the judge to make an informed decision. And I say this in the context that in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is We don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso injustice. It's just not possible. It would have been an absurdity in the law. Now, in relation to Lord Simla, Lady Simla, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time, it was presumption of constitutionality, and certainly the onus was on the appellant, to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular, the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that? Lady Simna would have asked, is that the judge now has a duty to carry out the Oakes test or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
Right.
What is significant?
I'll check my notes. Right.
What is significant that comes from it is that, and we take pride in this, and I'm quoting, I'm paraphrasing our Chief Justice, and it's found, thank you, it's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society. Yes. Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that, would be developed by the Jamaican judiciary in light of circumstances in Jamaica, or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa. And if you even the Canadian and the United States, but what you'll see, what a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21.
Yeah.
But what's significant is that what is clear is that there is similar to in the Canadian jurisdiction that the test, which is the demonstrable justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us rather than imposed from outside.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b, it is the last flicker or shimmer of light to what it is to be a human.
Yeah.
And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it.
Yeah.
So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And he evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And the key thing before I depart, because I don't want to take up too much time,
well, you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, the Lords and the lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned, is tainted, was allowed to remain on a jury, to bring a verdict, simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror ought to have been removed to protect the fair trial right. And it is in that vein that I will say that there is no cure, no proviso, or no thought of a retrial or a second bite of the apple where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we know is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed. And I trust your wisdom on that. Thank you.
Thank you, Mr. Buchanan. Well, if we've heard all counsel on behalf of the appellants, then I'll turn to Mr. Knox. Now, Mr. Knox, I don't want to knock you off your stride before you've got started, but it would be helpful to us if you were able to address us first on the jury issues, and then we may consider whether we need to hear you on the JS2 issue.
My lord, yes. Doesn't knock me off my stride too far. But I have to read my handwriting as opposed to the typed. Can I go first with the first of the jury questions that remain? And go first of all to E4072, 4072. Which is in bundle 5A, if anyone's working from a hard copy. I would just like to show you what happened, because there is more to it than you were shown by my learned friend. The incident begins at 4072, 6th of February 2014, so it's about a month before the end of the trial. You'll see at the top of the page, court resumes at 2:25 p.m., but they're all in chambers with the judges, with the attorneys.
Yep.
And Marlene Catwell is the juror. And the first part I would like to take you to is at 4073. She says she said Perhaps I should just say, line 24, the witness, that's Catwell, one Friday, so it doesn't identify which Friday. When we weren't at court, I went to visit him, my son. We were supposed to go into the lobby, but him never come out in time. Just as him come out to me, Andrew St. John's came in that way. He saw me, he was a bit panicked, and I look at his face, and he was a bit panicked. It's not quite clear who he is, but perhaps he's talking about her son. And then she continues over the page.
Her son or St. John?
No, her own son.
But she says her own son didn't come out.
Okay, oh, he saw me, sorry. In other words, St. John saw me.
Yes,
He was
I think so.
I look at his face. Forgive me, my lady, yes. And then she goes on to say shortly afterwards, when he came out, when he came out of the vehicle, my son came in and him said to me, inaudible. I was a bit angry with my son. I was a bit angry because he knew that I was coming and I didn't want to meet up with them. So I think his delay makes St. John's would have seen me. So I was angry at him. I think I must be her son now. You know me and I come back because him see me. I never related anything. But she then goes on to talk about her conversation with her son. Near the end of the page, me tell him me and a boy in the jail fight. Me go at the medical centre and him said to me. So there's been some sort of fight. And then over the page, 4074, she says, no, Kartel saw him and say him see him mother a juror, and say St. John's tell him, but him not tell the other rest of the man. So she seems to have seen, or rather, Kartel appears to have been involved as well at some point. It's not always easy to understand quite what is going on. But then if one can drop down to the end of the page.
I think we can probably take it the judge understood what was going on.
But the judge, I'm not sure he necessarily did. But towards the end of the page, 4074, they who? She says, the prisoners at the bar are there, and my son is there, and they know that I am a juror. If anything should go down, probably, I don't know, if anything go down, I would hate to know that me is the one who have to bury you. And he said, Kartel said to him, he was saying if. So her concern is being on the jury, and then if the jury convicts these defendants, then she's going to be in trouble. Or her son might be in trouble, rather. Yeah. It's not that she personally is going to be attacked, but she's concerned about staying on the jury, because if she does and the jury convicts, then there might be trouble for her son. That's her concern. Then you see Mr. Finson, that's Mr. Palmer's counsel. She don't even have to say any more. Juror Kartel said to him, if he. And then the judge says, okay, what I want to know, though, how you feel. You can bother with this, you can bother with the burden and all of this burial thing you talk about. The witness, Your Honour, the only thing I am concerned about is my son's safety. They are there, he is there, they know him. Andrew St. John's is on the said block. All right, that's a lot. Please just step down for us, please. It's too much for her. Having heard what she said, I have changed my opinion. Yes, it's too much. So obviously at first he was thinking, this is storm in a teacup, but now he's thinking rather differently. And then the prosecutor, Mr. Taylor, does seem that concerns with her son. And if the authority can find a way to move her son from Horizon, my lord, so she could have peace of mind to continue on the jury, the judge says, no, her son is now in the custody of the state. And then, yes, all right. The view is, Mr. Taylor, as prosecuting counsel, I wasn't trying to be brief and brush or comment aside, but from the performance that I saw her, it's clear to me for a parent to be placed in that situation that the body that she's sitting on may make a decision that may affect the safety of her son adversely. As a parent, it is an act that you don't want to place her in. In the circumstances, I don't think it's something she can properly deal with. You saw her performance just now. And then he goes on to say, therefore, I think I had better discharge her. And then towards 4077, towards the end of the page, Mr. Rogers, I think he's Mr. St. John's counsel, but I stand to be corrected, Another issue. For the record, I would hope that what has happened was not discussed in the jury room. And as a consequence of that, it might have been left with the rest of the jurors. I know it's a painful aspect at this point, but a real concern. May I inquire through the registrar as to any particular person in respect of the jury who would be seized of this information? Registrar, when the information came, sir, two persons spoke to me, that lady and the foreman, that forewoman. I inquired if anybody else is aware of the situation, and she said, no, just the two of them. So that would presumably be the forewoman and the juror.
Yeah. If you're going to read on, I don't think we need to read aloud the foreman's name.
No. My lords, my lady, if you could just read on to the end of to 4080, to the end of 4080, you will see what the upshot was and what takes place. So, my lords, my lady, what you get out of this is no one else knows except the forewoman and Catwell. It's not gone to the jury. And my lords, my lady, there's no reason at all to doubt that. Because even the forewoman, I think, says she only found out on this very day. And then the judge finishes at 4081 saying, I'll make an announcement that she has a personal difficulty, and I'll dismiss her. Now, in my submission, there's nothing wrong with any of this. This is a perfectly sensible way of dealing with the matter. The judge has assured himself that no one else
the trial by judge. Of its conclusion on the issue of juror misconduct, the board holds that it is not necessary to express a concluded view on the other two grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.
My people are what just go on. Because me that do something else and not hear what go on. I what go on, a freedom or what? Let me see in the comment section. What go on? We say real boss free or a retrial? And what go on? Can I come like my last in the system right now, my people? Blood clot, world boss free, my people. I what go on? It come like, I what go on? Yeah. My people, let's confirm this because me don't hear what go on a while ago. Is it a retrial or Vybz Kartel free? I swear my people, my last to the game show me out for a minute and I listen what go on. Mm. My people, wanna update me in the chat because I'm last to the system what go on a while ago. I wasn't listening. Think retrial, but based on what they say, he should be free. They allow the appeal. All right, my people, we just have to wait till it continue because my last. The Privy Council has sent back the murder case involving dancehall artist Vybz Kartel to the local court for a decision on whether it should be retried. The Privy Council has. And that's what take place, my people. The Privy Council has sent back the murder case involving dancehall artist Vybz Kartel to the local court for a decision whether it should be free. The appeal court has decided if there will be a retrial based on the judge action. They did not say retrial. They said appeal should be allowed, so he should be allowed retrial or should be allowed